All persons having business before this court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court.
Please be seated. Well, welcome to the 5th District Court of Appeal. As you've heard, my name is David Monaco. Well, you're anxious today, aren't you? Seated with me today are Judge Palmer and Judge Jacobus. We have 5 all civil cases today, 20 minutes aside. If the appellant wishes to reserve time for rebuttal, please let me know. I'll build it into the clock. When that yellow light goes on, that means you're into your rebuttal time. When the red light goes on, it means you should really stop talking. If anyone here has a cell phone, matter of fact I do, please turn it into the off position so that the parties aren't disturbed in the event that you get a phone call. We apologize. I noticed it's a little stuffy in here today.
We're saving money on it. We're saving money.
That has nothing to do with the quality with the quality of the judges. It's purely this.
But we are what is called a hot bench today.
That's right.
So if you all can keep your arguments to about 3-4 minutes each, we can all get out of here quicker. All right, with that...
Let me just say one thing. You know, today is Judge Monaco's last oral argument. He's retiring at the end of the month, so this is it for the judge. And, you know, it's been my pleasure to serve with him. It's been a privilege for me. And, you know, I don't care what other people say. He does know where first base is. As far as I'm concerned.
Well, you know, it's really great to see a bunch of old friends arguing in the first case today. That's a real privilege.
We're getting a little misty-eyed up here. And it's, you know.
All right, so Miss Egan.
Watch the term, old sir.
Yes.
We got Jamie, we got Barbara.
Yeah.
What the heck, you know? All right,
Barbara, you're up.
May it please the court, my name is Barbara Egan, and I represent the plaintiff in this case, the father of John Cody Moore, a minor, and we would like to reserve 3 minutes for rebuttal.
3 minutes. 3
minutes, yes, Your Honor. And I'll try to move as fast as I can. This case, as a reminder, arrives before this court as the result of a final judgment of dismissal with prejudice of the plaintiff's complaint below. The appellant in this case, Mr. Moore, the father of the minor, alleged in his complaint that both defendants had acted unreasonably in fulfilling their duties of due care when participating in this game. Again, it was a church league game. And the case was, the dismissals argued by the defendants involved 2 issues, Your Honor. One, as to the church and as to the individual player, a lack of duty and a failure to state a cause of action because no recognized duty was alleged. And number 2, that liability was based upon the doctrine of express assumption of the risk by a voluntary participating in a contract sport. And I think Judge Jacobus's comments were great that you know where first base is, because this is this involves an amateur softball game. At the point of the complaint, no one knows what the rules of the game were, what the compositions of the teams were, a plethora of factual questions that actually were resolved on the face of the complaint improperly. As to the duty claim, I think the Supreme Court made it very clear in the Cuner v. Green case from the 80s that in Florida the simple negligence claim is alive and well even in the context of an express assumption of the risk by voluntary participation defense. And so the duty issue, and Justice Boyd actually talked about it in his concurrence in Cuner v. Green, that the court had leapt beyond prior precedents by accepting the principle that a sport participant may recover damages for injuries resulting from simple negligence. So I think, and I think Mr. Doorneweed's counsel agreed with me, less so the church, that this duty issue is kind of intertwined in the evaluation of the express assumption of the risk doctrine. This doctrine is recognized.
How good does the player have to be? In other words, does the duty arise when it's a professional player? Would it be a college player? Would it be? I mean, how do you determine when the duty arises?
Well, I think as is pointed out in evaluation of any duty, it depends on the facts and circumstances of the case.
So you think it's always a factual determination as opposed to a law determination?
I think when you've got an issue, well, duty.
I mean, a professional player might be better actually, and might be less risk, because they have played professional baseball. That their skills are such that you might be at less risk than someone that isn't so great.
And I think that precisely.
So does it apply all the time? I mean, if you really got a bad player, does the duty arise then too, or no?
Well,
it's a duty to disclose, right? That's what you're talking about.
Yeah.
I think there's a duty to make the conditions as
You got a
safe
guy
as
here
they
that
appear
can't
to
get
be.
first base. Do you want to play today with him, or you got a guy that's a professional? I mean, where do you draw the line? Is it always there?
I think you're kind of getting to some of the factual issues that would underlie this, because the plaintiff is alleging that he creates a more dangerous position because he's got the professional instincts.
Seems to me it could be safer.
Exactly. So there's your factual. These are things for an expert. Does the professional player create greater risk? And I know man on the street type test. You ask a parent, would you allow your 14 or 15-year-old to play against a professional player? It's absolutely not, because I
got a 7-year-old grandson that can throw a ball like a rocket. Mm-hmm. If he was on the team, we have to say, well, look, he's 7 years old, but he can throw he can throw hard.
I see a distinction between the two conditions, because the players. And absolutely, I don't think you have to.
Would you have to have a list of your players and say, look, here's the skill set for each guy?
No, I don't.
I mean, that would be one way to disclose it.
Yeah, it would be one way, but if you've got a condition that is likely to, or that may create a greater risk, because we've got a guy that throws the ball at 90 miles an hour and has the instincts, and we've got potentially a
Was that alleged, that he throws the ball at 90 miles an hour?
Yes, Your Honor, yes.
Was this dismissal with prejudice? Did you seek to amend, or did you basically say, I've got all the facts I need here so it can be with prejudice?
I think what happened, and Your Honor, the record does not reflect whether counsel sought to amend or not. We did seek rehearing and did point out that perhaps some amendments would be necessary, but I don't initially.
You don't have an issue on appeal.
I don't have an issue on
there's
appeal.
Other facts you could allege.
Absolutely.
It rises and falls on what's actually alleged in the complaint.
Absolutely.
But the duty you're alleging is a duty to disclose.
The duty.
Not some different duty.
The duty we're alleging is the duty to disclose conditions that might be hidden or that make the game less safe than it appears to be. We don't even know.
The condition is there's a former professional ball player on one of the teams.
Yes, Your Honor. We don't even know at this point what the rules of this game were. We don't even know if adults were permitted under these rules. So, you have to, and you have to take in consideration the closer scrutiny that is given to this sport when minors are involved, and if it's like in the Allen case that was argued by my opposing counsel from New Hampshire, where it's a co-ed adult situation. Here we have apparently a league where children and adults play, and there has to be some type of abilities to keep the game as safe as it would be, keep the inherent risks at a normal level. And there is a case out of I forget what state, but it's Egan, where the courts recognize that when you insert an adult playing against a child, just the fact of the greater strength can cause a risk that's not inherent to the normal amateur league game.
So you could always get past a motion to dismiss if it was an adult that injured a minor and they were playing against each other?
I can't say that you would always get past a motion to dismiss, but in general you would, just as you do in most negligence claims, because it's the duty that arises is based on the circumstance, the circumstances of the case, and we have the negligence duty to use reasonable care.
Now it sounds like you've expanded the duty beyond the duty to disclose. I mean, if somebody's an obvious adult, now you're saying, well, maybe there's a duty not to play an adult against a child. Is that what you're saying?
Well, no, that would be taking it too far, but there's a duty to have some rules in place or have some type of safeguards so that or at least so that the parents know what their children are being exposed to. I mean, I think there's a great difference. I mean, we can take it to the extreme, but I think there's a great difference between a professional adult playing against minors and a more sandlot type family reunion type game.
The duty to have safeguards in place, is that
to
just
make the conditions as safe as they appear to be.
So that's not a disclosure issue?
It's not necessarily a disclosure
So you're alleging
issue.
some duty beyond a disclosure issue? You're actually having some additional duty to create some rules or safeguards or something else?
Yes, and I imagine there are rules for most of these league plays, and these things are typically addressed in the rules, and an evaluation of adherence to the rules is part of the evaluation of what goes beyond the inherent risks of the game itself. And nothing could be, what was pled in this complaint was a simple negligence complaint for failure to exercise reasonable care because they didn't warn, because they didn't disclose, because we don't know what effect the strength, skill, and instincts of this professional had on the risk to children. Was it greater than was his conduct? We do know that he threw down from third to second base while a minor was running down the base. Did he have a duty potentially to, and I don't know. I mean, this is something this court has to decide because there's not any similar cases out there dealing with these specific circumstances. But if we move to the express assumption of the risk defense, which it was alleged, and that's all intertwined because there's this concept that you assume the risk, you waive the risks inherent to the contact sport that you are playing. When you're dealing with a minor, you have, as pointed out in the Cicernos case, the minor is not even sui generis. So how in Cicernos, the court stated, and it was in a totally different context with a promise not to match him against heavier players, but the court specifically noted in dicta that had he been sui juris, and had there not been this allegation of this promise, the contact voluntary participation in contact sports defense may have applied. But you had those two things that the court was puzzled about, and the defense of express assumption of the risk is a fact-intense defense They're really...
But you don't get to it unless you get over the duty element, right?
And the duty, but the duty involves some of the, well, at least one of the elements, the inherent risk element in express assumption of the risk. Is it an inherent risk, or was that risk exacerbated? And also, with express assumption of the risk, there's the issue of voluntary participation on voluntary waiver by a child. On the face of this complaint, we don't know if this was John Cody Moore's very first softball game. We don't know what he knew about it. We don't know what the parents knew. We don't know what the parents agreed to. And all of those things are typically, or are always, fact questions.
Well, aren't they typically alleged? I mean, would they be in the complaint?
I don't know if they're typically alleged. We have our pleading requirements that you must allege ultimate facts, and in this case, and you don't have to allege all of the specific facts. It's usually clarified in further proceedings after discovery. But in
if you're relying on promises to do something or the existence of rules that were violated, that would certainly have to be pled. I mean, as I understand it, what happened was the third baseman threw from third toward second and hit John Cody, I guess, in the head with a softball. Right?
Yes.
Isn't that part of the inherent part of this game?
Well, it's the fact of that there are errant balls.
Yeah, that's pretty common.
And softball, you have to look at the conduct where the errant ball came from, and we don't know on this complaint whether the fact that this gentleman is used to exercising these complicated plays, did he create danger? Who knows who was on second base? Could they have even caught one of his balls? We don't. These are factual questions, and that's the issue to me and to the plaintiff. While it's not on the record, the father did not realize what was, and I don't know whether, like I said, I don't know if there were rules of this game, but it was a league. And I think that there probably would have been some requests for amendment down the line as the issues were developed through discovery. What were the rules of play here? And the other overriding issue for this that I touched on a moment ago is that we are dealing with children, which is very, very different in assessment of the risk. So I believe that that is a situation that's different from the other cases.
So if John Cody Moore were an adult, you wouldn't have a cause of action?
I think if John Cody Moore were an adult, it might start to fall more into that New Hampshire Allen case scenario, and there possibly would not be a cause of action because it would be equal players in the context of...
So you'd have no duty to disclose the quality of players if this was an all-adult league, even if somebody was a former pro?
In all-adult leagues, typically, the duty to disclose is subsumed under the rating of the league. I've played on a city league before, and you're rated D, so you're assumed to be playing with members of the D.
And if somebody brought in a former pro player to the D league, but it was all adults playing, there'd be no cause of action because there's a different duty to minors than there are to adults?
There might be a cause of action under those circumstances, but I'm not sure because you've got a different understanding set of skills with adults. Potentially, if it was hidden and this was a D League team, and they brought in a professional that could throw the ball at 90 miles an hour and knew what he was doing and nobody else did, it could be a problem. But I'm going to reserve the final 2 minutes for for reply. For oral argument.
I got it. All right, Mr. DeLugo, your turn at that.
No softball questions today from the judge.
That's right. The mighty Casey.
Good morning. May it please the court. My name is Michael DeLugo. I represent the First Baptist Church of Altamont Springs. I'm here with Ms. Jamie Moses. She represents Mr. DOORNEWEERD. We are going to try to share our time with the court's permission. I'd like to reserve 10 minutes for Ms. Moses, if I may. I love all of the baseball references and softball references in this case. What this case really boils down to at its core is a ground ball to third in which the third baseman fields the ball and throws to second base to record an out. That is an inherent part of the game of softball. And yes, it is unfortunate, it's tragic that the player was hit in the head with the softball, but even as it is alleged in the complaint, he was in the baseline when the ball hit him. That's part of the game of softball. The third baseman made a routine play, fielded the ball, threw the ball to second to record an out, and the ball hit the base runner who was in the baseline. There is no duty on the part of the church or on the part of the third baseman, whether he's a coach or a third baseman, or both, as is the case here. There's simply no duty recognized under Florida law.
There's a man on first, a man on second, right?
That is what is alleged. I believe at one point, one of the allegations is that
ground ball to the third baseman.
Correct.
Who's the professional, right?
He was a minor league baseball player.
He's trying to make the play at second.
I'm sorry?
He's making the play at second base? He's throwing to second base to make the out, the force out.
Correct.
Why didn't he just touch third, so this guy would be out too?
Well, it's interesting that you say that. Obviously, we have to accept all the allegations as true. At one point, there was an allegation that he was trying to execute a triple play, which suggests that he was going to touch third and then throw to second.
Could be.
But in any event, regardless of whether he touched third or not, it is apparent from the allegations of the complaint that he was attempting to record a force out at second base, and that's when the ball hit the base runner.
Okay.
Now, there's some confusion about whether he serves as a coach or not. There was some reference in the brief to it, but I don't see anything in the complaint. Was this guy a player and a coach, or just a player?
He was my understanding, and I'm basing this on the allegations of the complaint only and what was argued at the hearing on the motion to dismiss. I believe he was the coach as well. And again, since I represent the church, which was the sponsor of the team, but I believe the record reveals, at least it was alleged during the course of the hearing, that he was the coach as well. But I'm not sure that makes any difference to the court's analysis of whether a duty exists under the circumstances of this case. Quite simply, if this court were to conclude that a duty does exist under these circumstances, I'm not sure what would happen to recreational sports in the state of Florida. How would you ever have a recreational softball game or a recreational sport of any kind involving players of whatever varying skill you would find in any sandlot, any playground, any playing field, any basketball court, any soccer field in the state? I don't know how you would construct a rule of law following the appellant's theory that would be applicable under the facts of this case. Would there be a requirement? I think, Judge Monaco, you raised the point is this, you framed it as this, is there a duty to disclose? Well, what would you have to disclose? Would you have to disclose if someone had been a professional baseball player 20 years earlier? Would you have to disclose, as in my case, believe it or not, I was actually recruited to play soccer out of high school? If I were to play soccer now, would I have to disclose to the other team that I was recruited to play soccer in college?
There's no reason to resort to fantasy.
The point is, I don't believe that there is a rule of law that could be fashioned under the circumstances of this case. This was an ordinary softball play. There is an inherent risk in the contact sport of softball that a player may be struck by a thrown ball. Now, I know that there have been references to the fact that this may have been an errant throw. I don't believe it was an errant throw because it was a throw to second base and it struck the base runner who was in the base line. If the runner is in the baseline, then the throw apparently was on target, was going to second base. And again, it's unfortunate, it's tragic, but it doesn't give rise to a cause of action. It doesn't give rise to a duty on the part of either the church or Mr. DOORNEWEERD to either disclose his skill level to the other side. I mean, you would have a situation where would you have to disclose each player's, I think Judge Jacobus, you raised this point, would you have to create a list?
That's right.
of each player on your team, what's their height, what's their weight, what is their experience, and what special skills have they developed over the course of that experience. Again, I think that to rule that there is a duty under these circumstances would have a tremendous chilling effect on the participation in recreational sports in the state of Florida. Players cannot go out onto a playing field in fear that they're going to be sued if something that is inherently a part of the game occurs. And that is exactly what occurred here. And again, it's a question of law. There's been discussion by counsel for the appellant that this is inherently a fact issue. Well, duty is not a fact issue. I agree that, and I'm going to get to the assumption of risk argument in a moment.
It can be a mixed question.
It can be a mixed question, but I don't believe it is. I don't believe this case presents a mixed question. I believe in this case where you've got people voluntarily participating in a contact sport, and there is contact, the type of contact that is expected and anticipated in this type of sport, or a thrown ball strikes a base runner, and injuries result because of that inherent risk of the sport, then there is no duty that arises under those circumstances. Now, I agree that with regard to there being a factual issue, when you talk about assumption of risk, that can be a fact issue. I would argue that this case presents that tiny sliver of assumption of risk that still survives to this day. The Florida Supreme Court and the District Courts of Appeal have whittled away at the doctrine of assumption of risk over the course of the last 25 to 30 years, and I think rightfully so. But there is one little part of assumption of risk that still applies, and that is when there is voluntary participation in a contact sport and contact occurs that is part of one of the inherent risks of that sport, and that's exactly what happened here. I'm not sure if I have any more to add. If the court has any further questions, I would be happy to address them. Otherwise, I will rely on the briefs, and I will hand it over to Ms. Moses.
Thank you, counsel.
May it please the court, I'm Jamie Moses from the Fisher Rushmer firm in Orlando. I represent Mr. DOORNEWEERD, the appellee. I know there's going to be some joke that I just like to hear myself speak, but I promise I will make this short if the court so wishes.
That's not a joke.
There are just a few things I'd like to bring to the court's attention. You asked if he was alleged to be the coach. He is alleged to be the coach of his own team, not the coach of plaintiff's team. There is a reference to this being a D league. Mr. DOORNEWEERD, my client, was on the D team, and plaintiff's son was on a C-rated team, which is also an issue. He was actually on a team that was considered a better team.
So you're saying there's a factual issue that needs to be decided?
No, I'm not. I'm saying that this is not a D league as represented by counsel. With respect to the Egan case that was brought up, the distinction in that case was not that the injured party was a 10-year-old child and it was a wiffle ball game against an adult. The distinction in the Egan case is that the adult chose to use an aluminum bat instead of a wiffle ball bat. And the court said, although the 10-year-old could appreciate the risks of that game, he could not with an aluminum bat. And then finally, I just would like to bring to the court's attention a statement made by the Florida Supreme Court in Mazo versus City of Sebastian. And the court said, knowing involuntary participation in contact sports constitutes an express assumption of the risks essential to protect the other participants from unwarranted liability for injuries due to bodily contact inherent in the sport. This is what this case is about. Mr. DOORNEWEERD is an opposing player trying to make an out in a softball game. That's the entire purpose of catching a ball and throwing it to another player, is to record an out. That's what he did. That's inherent in this game. There is no way that the complaint could be amended, but it's already been conceded that there were no further amendments that would need to be done. But this is simply an inherent risk of the game, and therefore the defendants were entitled to a dismissal with prejudice, and we would ask that you affirm the trial court's dismissal. Thank you.
Thank you, counsel. All right, I think we're now ready for Ms. Egan. You have a little more than 2 minutes to go.
In the complaint, the plaintiff alleges that the plaintiff created an unreasonably dangerous condition and circumstances about which the plaintiff was unaware and could not appreciate. FBCAS, which is the church, never warned or notified the plaintiff or his team of the composition of the FBCAS team. I think there's been a lot of talk, or there's been questions from at least Judge Palmer and some comments by the counsel for the church that it would be not in keeping with the sport that we all have to say exactly who's playing on each team every time you play a team or you've violated a duty. I think what the issue here in this case is that these were C and D league team members, and when you have someone playing in a C or D, which are the lowest rung of the thing, that is outside of the normal skill level of those types of players, it would be your duty of reasonable care to disclose that so that the parents and the children would know against whom they were playing. And we're not trying. We're not trying to destroy softball. It's just when you've got these unusual situations that go outside of the normal inherent risk. And the issue is, and we still have to look at the conduct and also the result of the conduct in evaluating the inherent nature of the sport. And these are generally jury questions. It's not just that somebody got hit by a ball thrown by down the baseline. You were hit by a ball thrown by a professional that would not normally be on a D or C league. And we would ask that, my time's up, so we would ask this court to reverse the judgments of dismissal with prejudice and return to the trial court for further proceedings. Thank you, and thank you, Judge Monaco.